The contributions by way of electoral bonds to just this one party ruling at the center is more than 5,000 crores in just a period of less than 5 years. Now just look at that figure. The limit for spending on each candidate fixed by the legislature is less than 1 crore per Lok Sabha constituency. Less than 1 crore. Yes, the requirement is that they have to give a KYC, whoever purchases electoral bonds. So the identity of the person who purchases the electoral bonds will be known to the State Bank of India. But because they have now opened the route by making this amendment that the limit of 7.5% of the annual profits has been totally removed. So even if you are a loss-making company, or even if you are a company which does no business, just a pure shell company, let's say, my lord, your lordship is aware that in that Adani SEBI matter, they are saying, SEBI is saying, we don't know whether these companies who have invested in the Adani companies from Mauritius and from these tax havens, whether they are in fact owned by Adani or not, or whether they are related to Adani or not. Now it is open to any of these companies to set up a subsidiary in India and donate to any political party of their choice any amount, even if it's a pure shell company, which means no business, no profits, just an amount is received from its parent company, which is registered in a tax haven, and that amount is given to a political party. So one of my arguments, my lord, I have three main arguments which I am going to argue before your lordship against these electoral bonds. The first is that it defeats the people's right to be informed about the sources of funding of political parties, which in my respectful submission and in the light of several judgments of this court, is a fundamental right of citizens under Article 19(1)(a). That's the first argument. Because right to information has been held to be a fundamental right under Article 19(1)(a). In fact, in that ADR judgment and then in the follow-up PUCL judgment, this court said that every citizen has a fundamental right to know about the assets and liabilities of every candidate, about the criminal antecedents. And when that was sought to be overcome by means of an amendment, that amendment was struck down on this precise ground.
Right, that's the first submission. What is the second?
That's the first. Second is that this opaque instrument, anonymous instrument, in fact, promotes corruption in the country because there is good reason to believe, and I'll show my lord why, that these bonds are being given by way of kickbacks. Kickbacks to parties in power. Almost all the bonds have been received only by parties in power. More than 50% have been received only by the ruling party at the center, and the rest have been received only by the ruling party in the states. Virtually nothing, not even 1%, has been received by opposition parties which are not ruling in the center or at the states. And virtually all the bonds have been purchased by corporates, by companies, because they are almost all of denomination of 1 crore and above. 95% are in the denomination of 1 crore. 1 crore. Therefore, my lord, and you have simultaneously amended you have removed the cap on corporate donations and amended FCRA.
All right, there's a second submission.
That's the second submission. The third submission is, my lord, it disturbs and indeed destroys democracy in this country because it does not allow a level playing field between political parties which are ruling versus political parties which are in opposition, or between political parties and independent candidates. It will have, in fact, my lord, just to give your lordship a small figure, in the last 5 years, of which since the electoral bonds were introduced, 2017 they were introduced, 17, 18 to 21, 22, 5 years? 5 years. The contribution to political parties by way of electoral bonds has far exceeded any other method of contributing to political parties. Not only that, the amounts are so large. Just take one party, the ruling party at the center. The contributions by way of electoral bonds to just this one party ruling at the center is more than 5,000 crores in just a period of less than 5 years. Now just look at that figure. The limit for spending on each candidate fixed by the legislature is less than 1 crore per Lok Sabha constituency, less than 1 crore. If you set up candidates in all the constituencies in the country, the total amount that can be spent by the candidates of any political party is less than 500 crores in a Lok Sabha election. In just these 5 years, one party which has received the bulk of the political funding by way of electoral bonds is getting more than 10 times the maximum permissible expenditure on elections by its candidates. More than 10 times. So just see, my lord, what this is doing to our democracy.
What is the maximum permissible limit for a candidate?
70 lakhs or so.
Parliamentary constituency.
70 lakhs.
Of course, my lord, this limit is not adhered to. We all know that, because candidates are spending 10 times, sometimes 100 times the amount in cash. Now, Election Commission says, though it's a corrupt practice, spending more than the limit is a corrupt practice. But Election Commission says, look, we can't catch them. Everybody knows that many candidates are spending many times by cash. One of the arguments in this for introducing electoral bonds was, the stated argument of the government was that, well, this goes through the bank. These electoral bonds can only be purchased through bank transactions by check, draft or direct transfer. Therefore, it will reduce cash. That was their argument. But I think very simple. If you wanted to curb the role of cash in elections, all that you had to do was to pass a simple amendment saying no political party or candidate shall be allowed to spend or take any money through non-banking channels. Everything will have to go through banking channels. And if you do that, it will be a corrupt practice. Suppose such an amendment, when this note ban was brought, Lord, one of the objectives, given stated objectives of the government was that we want to make a cashless economy because we want the role of cash to be reduced. Now, I can understand that ordinary person on the street can't be made cashless. He can't be expected to do all his transactions through check and banking channels. But political parties and candidates contesting elections, they could have been made cashless by this simple law saying that you have to, or if you are a candidate or if you are a political party, all your transactions have to be through banking channels. But that was not done.
All right, now, Mr. Bhushan, let's do this. Let's look at the scheme of the electoral bond.
Yes.
And then you can make your submission.
Yes.
We've seen the amendments which have been made.
I fought the election in 2014 and it was 70. Today, whether it's 95 or 75 for a parliamentary constituency.
How much? 95?
95 or 75, depending on the state. For example, Andhra Pradesh is 95, Arunachal is 75. And for state elections, it's 40 and 28.
It's out of when you do you have to maintain a separate account for all this?
Yes.
Every candidate has
every day, mothers, we have to submit what we have spent every day.
Every candidate as well as every political party.
Yeah, they could.
Yes.
And this is reflected in the conduct of election rules, Rule 90 gives this table, so that your lordships have done.
Just one last thing I wanted to show, the amendment in the FCRA, just for your lordship's clarity. That is at page. So earlier, my lord, foreign source included. 3 is a foreign company. By this amendment, at page 11, my lord, provided that where the nominal value of the share capital is within the limit specified under FEMA or rules or regulations made thereunder, then, notwithstanding the nominal value of the share capital of a company being more than 1/2 of such value at the time of making the contribution, such company shall not be a foreign source. So if you are a subsidiary of a foreign company and you own even 100% of the shares of your subsidiary, provided it is within FEMA, it's not regarded as a foreign source. So even the subsidiary of a foreign company can now donate to political parties. That's why this is important. Actually, this was a whole slew of amendments brought almost together, 2016 and 2017. It's a bouquet. And by this bouquet, because that limit has also been removed, therefore, my lord, it's allowing shell companies also to donate. Earlier, shell companies could not have because there was a limit, 7.5%. Now, shell companies can also donate. You can set up, you have a foreign company which is in a tax haven. You set up a subsidiary here as a shell company, and through that you buy electoral bonds and donate to a political party, and nobody comes to know that a foreign company is now financing this political party, or these companies are financing this particular political party, etc. Electoral bond means a bond issued in the nature of a promissory note, which shall be a bearer banking instrument and shall not carry the name of the buyer or the payee. It's like cash. Only difference is that it's a cash which can go up to 1 crore. It's a note which can go up to 1 crore, from 10,000 to 1 crore. Today, my lord, we have only notes of 500 rupees or less. Even 2,000 rupees has now been demonetized. But here, it's 10,000 to 1 crore. That's 1,000 to 1 crore. 1,000 to 1 crore. Only political parties registered under 29A of the RP Act and have secured not less than 1% of the votes polled in the last general election to the House of People or the Legislative Assembly, as the case may be, shall be eligible to receive the bond. So this itself restricts it to only those parties. Not all parties are eligible. Those who have received at least 1% vote, either in the Lok Sabha or in the State Assembly. The bond shall be encashed by an eligible political party only through a bank account with an authorized bank.